An essential part of estate planning is designated beneficiaries for your life insurance policy, 401k, and other financial accounts. A beneficiary is a person who receives someone's assets on their death. There is no correct choice when choosing the beneficiaries who will inherit from you. It's a personal decision. What must be handled properly, however, is the process of naming beneficiaries so that your loved ones can inherit what you desire for them. Let's look at beneficiary designations in a little more detail. Why should you have beneficiaries? A last will and testament doesn't provide for passing on many financial products, such as investments and retirement plans. Leaving behind those assets requires designating beneficiaries for each specific account. The people you choose will assume ownership of the funds when you die and can use the funds however they want. Although designating beneficiaries isn't mandatory, deciding not to name them can create issues for your family. Instead of having immediate access to the funds, your loved ones will have to go through probate for the court to authorize the distribution of your assets. The Benton and Washington County, Arkansas probate process can be time-consuming and costly. It can prevent your family from using the money they need to pay for necessary expenses immediately. Disputes can also arise if they disagree over who's entitled to the assets. Choosing a primary and a contingent beneficiary is crucial when you pick your beneficiaries. A primary beneficiary is a person who will receive the asset. A contingent beneficiary is a person second in line to receive the asset if the primary beneficiary dies. You can designate anyone as a beneficiary with some exceptions. Depending on who you pick, creating separate legal documents or setting up additional accounts may be necessary. The most common parties designated as beneficiaries include immediate family. A spouse, child, or sibling is an excellent choice for a beneficiary. You can name multiple beneficiaries and instruct how the assets should be divided between them. You can name a minor child as your beneficiary. However, you must appoint a legal guardian to manage the funds if you pass away while the child is under 18. Typically, minors can't control financial accounts until they are legal adults. Your attorney may advise making your trust the beneficiary of certain accounts, especially if they are to be managed on behalf of a minor child or a person with special needs. If you have a retirement account, life insurance, or investments through a financial advisor, ask for a beneficiary designation form to complete. Banks can provide the form for checking and savings accounts. You can talk to your employer about adding beneficiaries to your 401k or profit-sharing plan. Beneficiary designations often require the person's full legal name and maybe some other details, like their relationship to you, social security number, mailing address, phone number, date of birth, and maybe more. Providing up-to-date information is crucial to avoid unnecessary delays while the insurance company or financial service company tries to locate your beneficiaries. Ensure all the details are accurate and make changes whenever necessary. You must update the form immediately if your chosen beneficiary dies.